Our next matter for the court is People versus Danny Smith. It is file 23S29871FH. Mr. Smith appears by video from the Montgomery County Jail. His attorney, Ms. Stan, is present in court. Today is the time and date set for sentencing.
Mr. Valet, then anything on behalf of the people?
Your Honor, we're asking to follow the recommendation that's made here. I think it's appropriate. I would remind the court that when these offenses occurred, Mr. Smith was an absconder on parole. And given his criminal history, I think this is an appropriate sentence.
All right. How about on behalf of your client?
Your Honor, did you receive a copy of the sentencing memo that I filed?
I do not have it.
Okay.
Just give me 1 minute.
Sure.
Okay. Then go ahead.
Thank you, Your Honor. I'll mostly rely on my sentencing memo. I just like to reiterate that Mr. Smith is a person with a severe substance abuse issue. In order to rectify a situation, he's in need of some very intensive treatment and counseling. He's very open and willing to do that. A lot of times you hear the saying that someone has to hit their rock bottom before they make those changes. I believe Mr. Smith has finally hit his rock bottom. He was released on parole and he did abscond. Unfortunately, substances affected his judgment in a way that he regrets, but he does want to accept the consequences. I would just ask that this court consider going below the recommendation and fashioning a sentence that allows him to be rehabilitated so that he will not be back in front of your honor for the same sort of issues.
All right, then Mr. Smith, anything that you'd like to say before the court proposes sentence?
Yes, sir. Your Honor, I'd like to say I've been to the penitentiary 3 times. And sir, I have done but mess my head up to the point where it's hard for me to function in society. I'm becoming institutionalized. I went at the young age of 17. My brain wasn't developed yet, and it's messing my head up, sir. And I need help. I'm sitting here begging for help for a program, for rehab, or something to help me structure my life back on track to be a productive citizen in society. And I feel like prison is not the best option, sir. I've been there 3 times. Let's try a different route. I'm asking for help, sir. And I've up to this point, you know, I accept everything I've done. You know what I mean? I take full responsibility for it, but at the same time, it's like penitentiary making me so I can't even function in the real world. I'm institutionalized, like I said, sir. So by me sitting here today, you know, I ask you for help, sir, for rehabilitation.
Anything else?
That's it, sir.
All right. Well, Mr. Smith, I've had a chance to review the PSI. I've also had a chance to look at the sentencing memorandum that was submitted on your behalf. And I don't have any doubt that there is a substance abuse issue, and that is something that's obvious from the PSI. What's also obvious from the PSI, though, is you're standing before the court today with 6 prior felonies, 4 prior misdemeanors. You were on parole at the time you committed this offense. Now, if I understand you correctly, your response to this is you've been institutionalized, and it's clear from the PSI you've been in prison on more than one occasion, but yet you don't take advantage of any of those tools that have been given to you throughout the years. Mr. Smith, in fact, your attorney's not here a lot either. I don't recall her in my courtroom, but other people that are here frequently will hear me talk about this on occasion. And I just came back from a judicial conference, which is required by the Supreme Court. All the judges of the state have to be at this conference where we learn all kinds of things. Some would call it maybe indoctrination. But in any event, I listened to at a session, I listened to Heidi Washington, director of the Michigan Department of Corrections. And she touted strongly their numbers, meaning the Department of Corrections, a place that you're familiar with, and how low the recidivism rate is for the state of Michigan's parolees, down in the low 20s, one of the best in the entire nation. And they attribute that to all of the program they offer people just like you. Now, if it works for 80-some% of parolees, then obviously You are the individual that's got to take advantage of all of that programming. I don't buy the idea that you haven't had an opportunity to address your problem in the past because you wouldn't have been paroled without completing programming first and foremost. You wouldn't have been on parole without having been required to participate in some of the programming that would help you address this drug problem, if that's really what's going on. And I don't doubt that it is, but I also think that there's you that plays an element in that. Do we really want to do the work that gets clean? Do we want to use the tools that we've learned through, I think, a couple paroles now, at least through different supervision periods to get clean? Those are all questions you've got to answer. But you stand before the court today with a guideline range of 2 to 34. You got an agreement for no more than 26. I think that the court, if the court were inclined, could make a more credible argument that it should be the top of the guidelines based on your history. You're only 34 years old. I just said you got 6 prior felonies, 4 prior misdemeanors, you got 10 convictions as an adult. So when we continue to do things over and over and over that end up in convictions, at some point, particularly with somebody like you that's been to the Department of Corrections before, that's been on supervision before, at some point, it's not what we are failing to do for you, it's what you are doing. It's the decisions you are making. So I'm going to follow the recommendations. I think it's appropriate here, but I think that hopefully gives you some background on why the court's following the recommendation. And more importantly, I hope you do everything that you said you want to do through the sentencing memorandum that you've indicated here. You're going to get a chance to address these issues. The Department of Corrections, if it's necessary, has medically assisted treatment programs. You'll have every opportunity to do exactly what you want to do, address this drug issue and go on and live a life free of crime. But you'll hold those keys and we'll see what happens. Time will tell. All right, I'm required and I will impose a $68 state cost. I'm required and I will impose a $130 crime victims assessment. There'll be $550 in court costs, a fine of $500, and I'm eliminating 5. You're retained. Is that right, counsel? Yeah. And then I'll follow the recommendation. I'm going to sentence you as a minimum sentence to 26 months with the Michigan Department of Corrections to the statutory max of, what do we have there, of 15 years. And pursuant to statute, though, sir, you won't receive credit for any days that you have served as a result of that parole status. And then also, this sentence would have to run consecutive to any sentence that you were serving.
He gets 1 day credit.
That's what it says, but where's the 1 day credit come from?
The detainer wasn't placed on him until the day after he was arrested.
Oh, see. More Department of Corrections breaks for their parolees because we want to make sure that they succeed. All right. So you'll receive credit for 1 day that then you have previously served. So, Mr. Smith, you do have a right to seek appellate review of the sentence the court's imposed. If you'd like to do that, you have 21 days from today's date to make that request. If you'd like a court-appointed attorney to assist you, you have a broader window of 42 days. So 21 and 42. Anything else, counsel?
No, you're not.
Okay, you're all set.
John Hubbard. Our next matter for the court is People versus John Robert Hubbard. It was filed 23S30015FH. Mr. Hubbard appears by video from the Montcalm County Jail. His attorney, Mr. Peterson, is present in court. Today is the time and date set for sentencing. But
I was just going to say, I mean, and I'm sure a reviewing court would frown on this, but we could have stuck both of these guys together right here and done one sentencing because they're within a year age of each other, almost the same criminal history, both on parole. The only difference is one was a drug charge and this is a gun charge. And there you go.
The difference is that there, and it actually is less of a difference because this situation, well, in the report, this situation arose out of, or their drugs were part of it. My client, in discussions with him, understands that he's got to change his ways. He understands there's programming at the MDOC, and it's his intention to take full advantage of that. Time will tell.
It will.
And that's what I told him.
Mr. Wood, just a quick question. You know that COVID is over, right? You can get a haircut now.
The haircut, I just got it cut, Judge. Actually, I just got about this much cut.
All right, it's good to see you, Mr. Wood.
Good to see you, Judge.